And now I would yield to the gentleman from Nebraska, the distinguished Vice Chair of the subcommittee, Mr. Terry, for 2 minutes.
The gentleman is recognized for 2 minutes.
Thank you, Mr. Chairman and Mr. Speaker. May I submit that my friend that just spoke on the other side maybe was the victim of some poor staff work that took some liberties to revise and extend the real bill that we're debating here today, because frankly the reforms here are fairly practical and necessary. What this really does is puts into the process of developing rules some simple changes that we think are reasonably necessary, keeping in mind that transparency is the key. So, for example, let's take the recent USF reform rule that came out. I've been active in USF, Mr. Speaker, for several years, trying to get some of these reforms done through Congress. It was taken up through the FCC process. I was anxious to see the proposed rule and was very disappointed when it was basically a rough outline of what turned out to be then passed. Then, several days later or weeks later, the full order came out, 750 pages. Now, don't you think that if you're going to vote on a proposed rule, that you would know what the rule says before you vote on it? It seems rather simple, and I would expect that people that are watching this debate would think that a bureaucracy issuing a proposed rule, that there'd actually be a transcript of the rule. So we're just asking for simple things like that. Then last, during this proposed rule, there's a time for then comment. And at the end of the comment period this last time, and this is why a shot clock is really necessary, is that the FCC then dumped volumes of documents that it said it was going to use as evidence in this process, giving people 48 hours. Now, the only ones, can I have 15 seconds? 15 seconds.
Gentleman's got 15 seconds.
The only ones that are least disadvantaged by that are the biggest entities that have a house full of lawyers that could go over it and read it. Rural Nebraska doesn't have the opportunity to do that and reply. So giving them opportunity, sufficient time to review that just makes common sense, and I yield back.
Gentleman yields back. Gentlelady from California is recognized.
Thank you, Mr. Chairman. Earlier, the chairman of the subcommittee said that the bill does not change the public interest standard for reviewing mergers. That simply is not the case. The bill does change it. It alters the ability of the FCC to impose conditions for the public interest, which is a very serious issue. I'd now like to call on the Chairman Emeritus of the Energy and Commerce Committee, the Dean of the House of Representatives, Mr. Dingell, for 3 minutes.
Gentleman from Michigan is recognized for 3 minutes.
I thank the distinguished gentlewoman. I ask unanimous consent to revise and extend my remarks.
Without objection.
Mr. Chairman, I begin by praising my good friend, the chairman of the subcommittee. It's just that he has brought us a bad piece of legislation. It should be rejected instantly by the House of Representatives because it does nothing to help anything. I refer to the Federal Communications Process Reform Act, which it is not. Time and time again, we Democrats have accused our Republican colleagues of passing bills that are solutions in search of problems. I would like to say that this is the same, but worse than that, I can say that we have before us a bill that is a prime example of trying to cure the disease and to kill the patient at the same time. In point of fact, H.R. 3309 would take the FCC entirely out of the Administrative Procedures Act and make it subject to a unique set of procedural requirements totally understood by no one. And if there have to be a bunch of lawyers hired, they will be hired, as a gentleman from Nebraska has pointed out, because they're sure going to need them to understand what has been done. Everybody in this chamber should have real fears about turning over 60 years of solid administrative jurisprudence and standing it on its head, and how that will bring about disastrous results, not only to the Commission, but to all of the entities regulated by that body, because nobody is going to understand what this has done. Mr. Speaker, Charles Fox wrote something called the India Resolution in 1783. It goes as follows: resolved that we have seen your work, and it will not do. H.R. 3309 evokes the same sorry sentiment. My friends on the other side of the aisle remind me that no Democrat has been a bigger critic of the FCC than I have. They're right. But that doesn't necessarily mean that I could agree with what they propose to do in H.R. 3309. Instead of passing a bad bill, which they don't understand, on which no adequate hearings have been held, and on which the industry is scared to death, we should get down to the business of having a decent proceedings in which we would go into this matter thoroughly as a matter of oversight, to compel the Commission to come forward to address the question of their accountability, of their transparency, and of their regulatory consistency. This Commerce Committee has skinned many cats in my days with that authority, and by the great horn spoon, we should do it again. But we shouldn't come on the floor waving a silly bill like this around, which is going to do nothing to benefit the society, and which the committee doesn't understand and cannot explain. Now, if I've got any time left, I'll yield to my friend.
The only
Gentleman's time has expired.
If gentlemen yield, the only comment I would make is we did have hearings on this legislation.
Of course, but they didn't relate to the matters that you have brought before the House at this time. You can't explain what's in this bill, and nobody here knows what it does.
The gentleman from Oregon is recognized.
I think, the Speaker, we can easily explain the bill. We know what's in it. We've had a lot of work on it. We've done public hearings. We've listened to people. We've modified it to accommodate some of the great suggestions we have. We have bipartisan pieces in this bill, and the Commission still has the authority to deny transfers of broadcast licenses. It just can't go outside of its statutory authority to promulgate rules and kind of grab other issues and force people to do things that they couldn't do under their statutory authority. I now yield to the gentleman from Georgia, Mr. Gingrey, 3 minutes.
Gentleman from Georgia is recognized for 3 minutes.
Mr. Chairman, I rise in strong support of H.R. 3309, the FCC Process Reform Act. And I'd like to take a moment to commend Communications Technology Subcommittee Chairman Greg Walden for his leadership on this legislation and his diligent work in moving it through regular order. Among the many reasons that it is necessary to make statutory reforms at the FCC, I would like to speak to one particular aspect of this legislation that I think is critically important to improving the way in which the FCC operates. H.R. 3309 will require the FCC to establish shot clocks to set timelines to compel the Commission to act. Under current law, where shot clocks are not compulsory, inconsistencies at the FCC continue to plague the telecommunications industry and have placed unnecessary burdens on our job creators. For example, there's an Atlanta-based company by the name of CBeyond that specializes in providing IT and communication services to small businesses across the country. They employ, Mr. Speaker, approximately 1,600 people. And like many employers within the industry, they're forced to wait on the whims of the FCC. Unfortunately, many case proceedings linger for years with no resolution, and this stifles growth for companies within the telecommunications industry. Just over 2 years ago, I, along with our former colleague and now Governor of Georgia, Nathan Deal, sent a letter to the FCC asking that they look closely at broadband infrastructure initiatives that would bolster one of our greatest assets for economic recovery, small businesses. In that letter, which I'd like to ask unanimous consent to include in the record, Mr. Chairman, we referenced a petition filed in November of 2009 that is now part of an FCC proceeding commonly referred to as the Business Broadband Docket, which is a proceeding focused on broadband infrastructure used to serve small businesses. Mr. Chairman, both the petition and the Business Broadband Docket remain pending at the FCC. not only with no resolution, but also no movement toward any conclusion. This behavior by the FCC is unacceptable, and it has occurred under both Democrats and Republicans. This anecdote highlights the need for a shot clock placed on the FCC. Not only do these shot clocks need to be established, but they also need to be honored. This alone will make the FCC work in a more efficient manner by creating more regulatory certainty in the telecommunications industry. I urge all of my colleagues to support establishing a shot clock at the FCC. Support H.R. 3309. I yield back, Mr. Chairman.
The gentleman yields back. The gentleman's requests to enter items into the record are covered under general leave. The gentlelady from California is recognized.
Mr. Chairman, I'd like to inquire how much time we have on this side remaining.
The gentlelady from California has 17 1/4 minutes remaining. The gentleman from Oregon has 9 1/4 minutes remaining.
Thank you.
At
this time, I'd like to recognize for 4 minutes the very distinguished and valued member of the subcommittee, Mr. Doyle of Pennsylvania.
The gentleman from Pennsylvania is recognized for 4 minutes.
Thank you, Mr. Speaker, and thank you to my colleague and friend Anna Eshoo, the ranking member of the Communications and Technology Subcommittee, for yielding. Mr. Speaker, I rise today in opposition to H.R. 3309, the FCC Process Reform Act. This legislation would place severe procedural burdens on the FCC at a time when telecommunications is such a major part of the lives of my constituents and the American public. H.R. 3309 would create harmful restrictions to the FCC's ability to enact consumer protections, and it could also limit the agency's ability to respond to communications-related emergencies and cybersecurity threats. One of the restrictions imposed by H.R. 3309 is a requirement that the FCC issue a notice of inquiry before the agency begins work on an actual rulemaking, unless the FCC can demonstrate that a notice of inquiry is not necessary. A notice of inquiry, Mr. Speaker, is basically an information-gathering exercise that lets the public know about the FCC's intentions to examine an issue and collects initial comments from stakeholders. While in many cases a notice of inquiry is a very important part of the FCC's rulemaking process, a congressional mandate to conduct a notice of inquiry in every FCC proceeding would be an enormous procedural burden for the agency. Mr. Speaker, I'm concerned that the potential impacts of this legislation have not been fully considered. If I could, I'd like to share just one example of the harmful potential consequences this legislation would have, even for bipartisan goals. Last year, Congress enacted a bill that I authored to create more community-run radio stations around the country. This bill was broadly supported by both sides of the aisle because so many of our constituents will benefit from more news reporting on local issues and emergency responses. The FCC is currently implementing that law and expects to open a window for radio station licensing sometime next year. But provisions in H.R. 3309, such as the requirement for a notice of inquiry, could slow down the implementation of this law and many other rulemakings by several years by adding procedural hurdles for the agency to jump through before it can implement rules. In the case of my legislation, the FCC would have to delay its licensing window because of an unnecessary notice of inquiry, forcing communities to wait longer to get their new radio stations. I think most people would find this kind of delay very frustrating. And this is just one example, Mr. Speaker. In the case of more contentious policy issues, this bill would create years, maybe decades of deadlock at the FCC. Mr. Speaker, we don't have to look very far this week to witness that our nation's laws and regulations are already being extensively litigated in the courts. This legislation would open up the FCC's process to even further litigation, and it would severely limit the FCC's ability to protect consumers and create new rules. I urge my colleagues to oppose this bill. I yield back my time.
The gentleman yields back. The gentleman from Oregon is recognized.
Mr. Chairman, before I yield to my colleague from New Hampshire, I just want to point out that we're not quite understanding the bill here on the other side, because we do allow the FCC to maintain flexibility where necessary. The bill only requires the notice of inquiry on new rulemakings. The requirement does not apply to deregulatory rulemakings, and the FCC may waive the notice of inquiry in emergencies or where conducting both a notice of inquiry and notice of proposed rulemaking would be infeasible. So we tried to put some balance in here, but what's wrong with having the FCC, even in that case as raised by Mr. Doyle, take 60 days, they can decide how long this is, and go out and survey the market and say what effect, what are the issues, and then come back and then they write their rules. It's like us having a hearing. This isn't a burdensome requirement. I now yield 1 minute to the gentleman from New Hampshire, Mr. Bass.
Gentleman from New Hampshire is recognized
Chairman,
for 1 minute.
I thank the gentleman from Oregon for yielding to me as a co-sponsor of this legislation. I'm pleased that the House is considering it. It's important reform procedures at the FCC. H.R. 3309 will improve the transparency, the fairness and consistency of this regulatory agency with oversight over telecommunications and technology, and will provide certainty to these markets that are so critical to our nation's economic recovery and growth. Indeed, over the past 8 years, landline, wireless, and cable providers have invested more than $500 billion in broadband infrastructure. This investment has created countless jobs for our nation and has positively affected our economy many times over. H.R. 3309 contains the common-sense, nonpartisan thrust of ensuring transparency and accountability of unelected bureaucrats by applying regulatory reform principles endorsed by the President's own January 2011 executive order, establishing clear timeframes for FCC action, requiring the FCC to perform a cost-benefit analysis before implementing new regulations will provide our nation's small businesses and innovators with the regulatory certainty necessary to invent and create new jobs. I urge passage of this important legislation. Thank you.
The gentleman's time has expired. The gentlelady from California is recognized.
Thank you, Mr. Chairman. At this time, I'd like to recognize the man that I call Mr. Telecommunications, the real expert in the House of Representatives, the gentleman from Massachusetts, Mr. Markey, for 3 minutes.
The gentleman from Massachusetts is recognized for 3 minutes.
I thank the gentlelady so much. I think all of us on the Democratic side would agree that if there was a way to streamline and strengthen the FCC's procedures, if we could find a way to improve the way in which it carries out its duties, well, we would support that. However, the aim of the Republican legislation is not to streamline the Federal Communications Commission. It's to straitjacket the Federal Communications Commission. This is a bill which would severely restrict the Commission's ability to operate effectively. If this bill becomes law, the FCC would stand for fully constrained commission. And that, ladies and gentlemen, is the goal of the Republicans in this legislation. It would establish a separate administrative process to govern the FCC's internal operations that would be different and more cumbersome than any other agency in the entire federal government without producing any policy benefits. Now, we know who supports the bill. AT&T, the big companies, they support this legislation. We also know who opposes this legislation. Every consumer group, every public interest group in the country says this is a particularly bad bill from a public interest perspective. But if you're AT&T, if you're a big company, you love this. This is going to tie the Commission in knots. You can continue to do whatever you feel like doing indefinitely because the Republicans have decided to create the most cumbersome regulatory process of any agency in the country. They're a model. They're pioneers here, the Republicans out here on the floor. They want to create the most modern red tape, tie them in knots agency possible with the hopes that other federal agencies would wind up emulating them. And It's going to be the first jobs bill that the Republicans have passed so far in this Congress, because this bill is going to create so many jobs for lobbyists, so many jobs for lawyers, so many jobs for all of the people who are now going to be put to work trying to untie this mess of a bill, of a regulatory agency that is going to be created by this process. So, ladies and gentlemen, this bill takes the public interest standard, the public benefits that has always been the test of whether or not the agency can, in fact, make a decision that ensures that the interests of all Americans are being protected, and turns it into something which is going to wind up with a harmful, drastic departure from current law. This bill is a wolf in sheep's clothing. Vote no.
Fired. The gentleman from Oregon is recognized.
Thank you, Mr. Speaker. I've never heard a finer defense of a broken bureaucratic process than I just heard. Let me point out that the National Association of Regulatory Utility Commissioners, now these are the folks that stand up for consumers and ratepayers, again, support many of the proposals in this bill. Specifically, they point out that the minimum 60-day comment cycle is good, that the mandating that all commissioners have adequate time to review any draft decision before voting on it is good, and to require the actual language of the proposed rule to be published for comment is a good idea. And again, the President's own executive orders ask for these things in many cases to be done to the other agencies, but he can't do it to this one. It's our job to do it here and to fix and reform and drive for accountability and transparency against those who defend the bureaucracy as broken as it is. I now yield 3 minutes to the gentlewoman from Tennessee, extraordinary member of our subcommittee, Ms. Blackburn.
The gentlelady from Tennessee is recognized for 3 minutes.
Thank you, and I thank the gentleman for yielding. You know, I find it so interesting as we are here debating this bill. This is only a 21-page bill. And I don't find, Mr. Speaker, in this bill, I don't find the word constrain and straitjacket anywhere. It does not exist in this bill, and as I've heard my colleagues talk about this bill, I think that they have not read the bill. So unlike the 2,300-page bill that is being debated at the Supreme Court across the street, I would encourage them to pick up this little 21-page bill and give it a read. I've also found it very interesting. The White House and this administration likes to say transparency is the cornerstone of their administration, but I have seen them go to just extreme lengths, it seems. The White House and the Senate to block bringing this process reform bill forward. Yesterday, the White House released a statement of administration policy saying, and I'm quoting, "It is generally recognized that the FCC has improved its practices and procedures to make it more effective." But the truth is, in the last 50 years, what we have seen is that their rules and regulation, their impact, their footprint has grown 800%. Not doubled, not a little bit a year, 800%. That is why we need this bill, and I commend the chairman for bringing the bill forward. Let me tell you a few things that this bill does. I think that they're common sense. It would do a few things like allowing more time for public comment. Well, my constituents want more time to weigh in on these issues as they find out about issues. More time is a very good thing. Measuring the agency's performance with scorecards. Our children have report cards. Knowing where you are and what you're doing and what kind of goal you're trying to reach, that is very healthy. That is a good thing. Making sure the agency doesn't attach extraneous regulation conditions on business transactions. We're talking about jobs and the effect of regulation on jobs. It is such a positive thing to pull back regulation and free up free enterprise. That is what we should be about, is making certain that we can move forward on these issues. Requiring the agency to do cost-benefit analysis for rules that cost more than $100 million. Well, how about that? Cost-benefit analysis. Is a rule going to be worth the cost? Is it going to be worth the effort, or is it going to be too expensive to afford? My goodness, we've had all sorts of things that they're too big to fail and too expensive to afford, so let's certainly make sure that we are evaluating these rules before they get put onto the books, before they have the force of law. Let's make certain that we pass this reform bill. I yield back.
Yields back. The gentlelady from California is recognized.
At this time, Mr. Chairman, I'd like to yield 2 minutes to the gentleman from Vermont, Mr. Welch.
The gentleman from Vermont is recognized for 2 minutes.
The microphone is working. You can go to that one as well.
Thank you. This is a bad bill. H.R. 3309 would create a special set of very vague and unique procedural hurdles for the FCC that apply to no other agency. It will result in decades of litigation. We have to have simplicity. We have to have clarity. This legislation will open up the floodgates of confusion. It significantly reduces the FCC's ability to take the public interest into account, and that is the fundamental interest that should be on the minds of this Congress. It provides endless routes for potentially misguided litigation, making every single one of the FCC's regulatory analyses in support of a new rule, and not just the rule itself, subject to judicial review. There's going to be regulation or not regulation. This legislation means there's endless litigation. These requirements would also amend the Communications Act to mandate how the agency should operate internally, with detailed requirements for the most basic regulatory actions, such as specific timelines associated with notice and comment rulemaking procedures. This is Congress micromanaging. Mr. Speaker, I urge the Congress to defeat this legislation, and I yield back.
The gentleman yields back. The gentleman from Oregon is recognized.
Could I inquire as to time on each side?
Yep. The gentleman from Oregon has 3 3/4 minutes remaining, and the gentlelady from California has 9.5 minutes remaining.
I will yield 2 minutes to the gentleman from Texas, distinguished former chairman of the committee, my friend Mr. Barton.
The gentleman from Texas is recognized for 2 minutes.
Thank the distinguished subcommittee chairman. Ask unanimous consent. Revise and what? What did I say? Revising? Extend.
Without objection.
Had a brain freeze there. Texas congressmen don't often quote Shakespeare, but I'm going to attempt it. There's a line in Hamlet that goes something to the effect that methinks the lady doth protest too much. And my friends on the Democratic side of the aisle seem to be protesting too much a very modest bill, 20-something pages in length. It's basically a good government bill. The bill basically says that the FCC, before they issue a rule, they've got to actually put it out for public comment for at least 30 days. And then once they formalize it, they've got to let people have another 30 days to comment on what they actually are proposing. Subcommittee Chairman Walden circulated a draft bill. To my knowledge, he circulated it to the entire committee and to the industry and the stakeholders. And I know in my case, I had a few modest suggestions that were incorporated in the bill, and then when he went to subcommittee, I offered an amendment that was accepted. He did the same process at full committee. It came to the Rules Committee. I'm told that there are, what, a dozen, half a dozen, 10 amendments have been made in order, 8 of those by my friends on the Democratic side of the aisle. We'll have that debate and the vote on those later today or tomorrow. So here you have a very modest, good government transparency and reporting, bring the FCC into the 21st century, how to do business bill. And you would think that we're going back to the dark ages. Nothing could be further from the truth. So I'm a very strong supporter of the process, which is important, and also the policy and the legislation that has resulted from it. and I would hope that on a bipartisan basis at the appropriate time we vote in the affirmative on H.R. 3309. It's a good piece of legislation. It can pass the Senate. It can be signed by the President, and it should be. With that, I yield back.
Gentleman's time's expired. The gentlelady from California is recognized.
Thank you, Mr. Chairman. I'd like to use some of our remaining time on this side to respond to several points that have been raised by my colleagues on the other side of the aisle. First, while the majority argues that H.R. 3309 is only a, quote, light touch in making sure that the FCC follows the Obama executive order on cost-benefit analysis, they fail to mention that such cost-benefit review is not judicially reviewable. And that's a very important fact here. The executive order states that it's, quote, not intended to and does not create any right or benefit, substantive or procedural, enforceable at law or in equity by any party against the United States. So H.R. 3309 therefore would create another avenue for appeal and litigation by corporate interests that oppose the FCC's efforts to take actions in the public interest. And no other federal agency would be subjected to such challenges. So that's number one, and that speaks to, I think, the public interest, and which I think is at the heart of what the FCC's responsibilities are. Second, Mr. Gingrey mentioned shot clocks. There are 73 types of proceedings the FCC must consider, and each item can be, as we all know, and anyone that's tuned in and listening to this, can be very complex. No wonder CBO estimated that 3309 would require the hiring of 20 additional employees. Thirdly, as the majority placed in the record, those that support the bill, and even Mr. Markey spoke of some of the large telecommunications companies, I think it's important to set down for the record who opposes the bill and what they have to say about it. Bruce Gottlieb in the National Journal, quote, layering new procedural requirements on top of existing ones would effectively halt the creation of nearly any contentious new FCC rules. In other words, achieve a result more or less like what Texas Governor Rick Perry had in mind for the Commerce and Education departments. Susan Crawford in Wired magazine. Although the bill's proponents say they aim to make things work more quickly at the FCC, the legislation will have the opposite effect. It will make it very difficult for the FCC to deal with any of the real-time telecom problems the country faces. What the Republicans seem to want at bottom is to grant the giant companies that sell us basic communications capacity and essential utility for the 21st century the ability to throw sand in the works at every opportunity. From Philip Weiser, the dean at the University of Colorado Law School, I am against passing this bill, which would give rise to unfortunate and unintended consequences that would undermine the FCC's future effectiveness without providing any real benefits. From the Consumers Union, the bill would require the FCC to adopt rules as long as they do not impose an additional burden on industry. The bill limits the FCC's ability to consider the public interest and protect consumers when considering mergers. This is no small item, Mr. Chairman. And then the Public Interest Group's coalition letter of February 9th of this year, these bills would severely hinder the FCC's ability to carry out its congressional mandate to promote competition, innovation, and the availability of communication services. And with that, Mr. Chairman, I'd like to inquire how much time we have left on our side.
The gentlelady from California has 5.5 minutes remaining.
And I will reserve that time.
Gentlelady from California reserves. The gentleman from Oregon.
Given the limited amount of time we have, I'll reserve as well.
Gentleman from Oregon reserves. Gentlelady from California.
We'll yield back, Mr. Chairman. I don't have any more speakers on the legislation.
Gentlelady from California yields back. The gentleman from Oregon is recognized. Gentleman from Oregon has 1 3/4 minutes remaining.
I thank the Speaker, the Chairman. I appreciate the debate that we've had today. I think it's been helpful. It hasn't always been enlightening, but it's been helpful to have. And again, I would point out that the National Association of Regulatory Utility Commissioners praises what we're doing in this bill in the points of requiring actual language to be available for people to see. You know, all we're doing here is telling the FCC operate like these other agencies have been asked to operate by the President's Jobs Council and by the President's executive order, but do so in a public and transparent way so that those who have business before the Commission know what the Commission is going to vote on before it votes or rewrites it and then puts it out later. Go out and survey the marketplace. Decide if there's a harm. Do a notice of inquiry and get input, and it's like we do in hearings here, Mr. Chairman, and then propose rules and put those texts out there of those rules and let the public see. The great defenders of the bureaucracy, my friends, some of them on the other side of the aisle, say, oh, you can't change anything in Washington. That's what we've heard for 40 years. Some of us came here to change Washington for the better. We did it when we changed the rules of the House at the beginning of this session to make our procedures more open and transparent. So my friends on the other side of the aisle were part of the effort that crammed 2,000-page bills through here with no amendments allowed on the floor, one of which is being argued right today across the street at the Supreme Court. Republicans were denied the opportunity to offer a single amendment on the health care takeover bill on the House floor. They were denied every single amendment. And then these bills would come to the floor thousands of pages. We changed how the House operates so that can't happen again. This bill's here under a modified open rule. The minority has 10 amendments on the floor. We had open markups in subcommittee and full committee. What we're saying is we are here as Republicans to change Washington for the better. This bill does that. I urge your support.
All time for general debate has expired. Pursuant to the rule, the amendment in the nature of a substitute recommended by the Committee on Energy and Commerce printed in the bill shall be considered as an original bill for the purpose of amendment under the 5-minute rule and shall be considered read. No amendment to the committee amendment in the nature of a substitute shall be in order except those printed in House Report 112-422. Each such amendment may be offered only in the order printed in the report by a member designated in the report, shall be considered read, shall be debatable for the time specified in the report, equally divided and controlled by the proponent and an opponent, shall not be subject to amendment, and shall not be subject to a demand for division of the question. It is now in order to consider Amendment Number 1, printed in House Report 112-422. For what purpose does the gentleman from New York seek recognition?
Mr. Chairman, I have an amendment at the desk.
The clerk will designate the amendment.
Amendment Number 1, printed in House Report Number 112-422, offered by Mr. Crowley of New York.
Pursuant to House Resolution 595, the gentleman from New York, Mr. Crowley, and a member opposed, each will control 5 minutes. The chair now recognizes the gentleman from New York.
Mr. Chairman, I yield myself as much time as I may consume.
Gentleman's recognized.
Mr. Chairman, I rise today in support of this amendment to H.R. 3309. Mr. Chairman, my amendment addresses a problem that has come to light over the past few years. It's a problem that's a concern for parents, a problem that is a concern for families. It's a problem that's a concern for law enforcement. And I believe that my amendment will help to address this problem. Here is what we have learned. Many families do not know that the baby monitors that they purchased to help them take care of their infants and their children can be easily accessed by potential intruders. It's possible for someone, anyone at all, to purchase a normal baby monitor at the store and use that monitor to see and hear inside a family's home, quite literally making it possible to monitor other people's children's and their lives. In fact, recent investigative news stories by NBC in New York and throughout the nation found that one can even drive down the street with a baby monitor receiver and monitor every child on that street whose family uses an analog baby monitor. Outsiders waiting hundreds of feet from a home or canvassing a neighborhood can quickly and easily see an image of a young child or an entire room, the same image seen by parents inside their home. The concerns don't end there. Potential intruders could also identify whether the parents or children are home at all, helping create conditions for burglary. And a potential kidnapper or abuser could easily identify the location of a child within a home, as well as the easiest point of entry to abduct or cause harm to that child. This is a situation that is deeply concerning to many parents who know of the problem, but equally as alarming is the fact that so many others don't even know about the problem to begin with. This amendment would direct the FCC, when ruling on baby monitors, to require companies producing analog baby monitors to include warning labels on packages so that parents can make fully informed decisions about the potential risk of their purchases. Parents have no greater concern than the well-being of their children and their families, and they deserve full information about the products they are purchasing. It comes down to making sure that parents are aware of any potential dangers. A clear warning on the monitors will help all parents with the information they need to make the best decision for their family. I have written to the FCC about this issue, as well as the Federal Trade Commission and the Consumer Product Safety Commission. There is indeed an interest in addressing this problem, and I hope passage of this amendment will send a clear message to the agencies with jurisdiction over these products that we need to find a way to move forward and get this matter addressed. I ask for support for this amendment, and with that, I yield back the balance of my time.
The gentleman from New York yields back. For purposes, the gentleman from Oregon seek recognition.
Mr. Chairman, I rise in opposition to the amendment.
The gentleman's recognized for 5 minutes.
I share the gentleman's concerns that he raised. A lot of people do not understand that, especially in the area of unlicensed spectrum, you don't have a right to a protective communication. And certainly in the analog world, you can listen in. We all know that from CB radios and things of that nature, where and the family networks, you hear other people talking. This is an issue of concern, certainly, because all of us want to protect our families, those of us who have children. Mine's now much older than that, at nearly 22. But this is certainly an issue, and I appreciate the gentleman raising it. And I know he has legislation, although I would say this is the wrong vehicle for that, because this is an FCC process reform bill, not a labeling bill, and the FCC does not use the phrase baby monitor in any of its rules, so in effect this labeling requirement may never take effect anyway, and if the labeling requirement does take effect, it may cause some consumer confusion, because you'd treat all analog monitors perhaps as unsafe and digital monitors as safe, even if that's not true for a particular brand of baby monitor. So I oppose this amendment and would encourage my colleagues to do likewise, and I yield back my time.
The question is on the amendment offered by the gentleman from New York. Those in favor will say aye.
Aye.
Those opposed will say no. In the opinion of the chair, the noes have it. The amendment is not agreed to. Gentleman from New York.
I request a recorded vote.
Pursuant to Clause 6 of Rule 18, further proceedings on the amendment offered by the gentleman from New York will be postponed. The chair understands that amendment number 2 will not be offered. It is now in order to consider amendment number 3, printed in House Report 112-422.
Chairman, I have an amendment.
The clerk will designate the amendment. Nope. It is now in order to consider Amendment Number 4, printed in House Report 112-422. For what purpose is the gentlewoman from California? It is now in order to consider Amendment Number 5, printed in House Report 112-422. For what purpose does the gentlewoman from California seek recognition?
To offer the amendment that's at the desk, Mr. Chairman.
The clerk will designate the amendment.
Amendment number 5, printed in House Report number 112-422, offered by Ms. Eshoo of California.
Pursuant to House Resolution 595, the gentlewoman from California, Ms. Eshoo, and a member opposed each will control 5 minutes. The chair now recognizes the gentlewoman from California.
Thank you, Mr. Chairman. I come to the floor this afternoon to offer an amendment to this bill that probably for most people, as they were tuned in and listening to the discussion and the debate of the bill, may not have gotten too excited about it because it deals with the innards of an agency. But this amendment, I think, is probably one of the most important parts of the bill, and I'm very pleased that the Rules Committee found it in order. This amendment goes to the heart of our democracy, and it's all about disclosure. We have the opportunity today to secure disclosure in political reporting for the voting public. There's something very sick about our system today. People across the country are deeply and profoundly upset about the undisclosed sums of money that are being poured over and through our political system. And when that happens, it goes right to the heart of democracy. Why? Because it's undisclosed. We do not know who is contributing. We don't know how much they're contributing. We don't even know if foreign countries are involved in this. And so this is really a very simple amendment. It's an amendment that adheres to the same principles that many of my colleagues, Democrats and Republicans, have supported before. And it works like this. If an organization buys political advertising time on broadcast television, on radio, on cable, or on satellite, they would be required to disclose their large donors, those who give $10,000 or more to air the ad. There is today, in statute, Section 315 of the Communications Act, and it's been in place since 2002, that covers issues of a national legislative issue of public importance. And it also covers legally qualified candidates or any election to federal office. So there's something already in place. The only thing that's being added to this is that if you're going to buy time, $10,000 or more, that you are required to disclose and name who the donors are, who's contributing that money. I think that this is very important. We are a democracy. We're not a plutocracy. And what I hear over and over and over and over again from my constituents is the damage that Citizens United, the case that the Supreme Court rendered the decision, I think a disastrous one, 2 years ago. We have the jurisdiction at the Energy and Commerce Committee and this subcommittee. It is within our jurisdiction to take this up in this bill. Now, there is something else. Some people have said that this is burdensome. Burdensome for broadcasters, burdensome for those that broadcast television, burdensome to radio, burdensome to cable, burdensome to satellite. They're not the ones that have to disclose. Only those that buy the time. And the files exist today. There is one file One file only. Now, there are other files for other responsibilities, but there's only one for political ads. Is America and our democracy not worth requiring those that want to buy the political ads to disclose who they are above $10,000, and that's it? So the law is already in place since 2002. The file is already there. There is no burden to the broadcasters, radio, TV, satellite, cable, as I said, but simply to report. Now, there are those that say that that would be burdensome, as well. My question is, how heavy of a burden is it? How heavy of a burden, how heavy of a lift is it to report and disclose to the American people? The American people have a right to know, and once they know, disclosure is a disinfectant. They will make up their own minds, and with that, I yield back my time.
The gentlelady's time has expired. What purpose does the gentleman from Oregon seek recognition?
Mr. Chairman, I rise in opposition to the amendment.
Gentleman's recognized for 5 minutes.
I don't rise in opposition to disclosure. I think that's a good thing, if it's done in the proper venue, in the proper way, and that's not on this particular bill. A similar amendment was brought before the full committee and rejected by the full committee. It has since been rewritten, and it's better than what came before the full committee, and I commend my friend from California for that. But the way that this is written, I believe it has lots of unintended consequences that could be difficult, and doesn't accomplish what she's trying to accomplish in an effective way. For example, my colleagues in the chamber, you all would have to disclose when you go to inquire about the purchase of time now on radio, TV, or satellite, or your $10,000 donors. So any PAC that gave you $10,000 the last 2 years would have to be listed. Now, my colleague from California, that would be like Abbott Labs and Google and McKesson that gave you 10, and I've got some that gave me 10, and you'd have to do that and disclose. You wouldn't have to do, you know, money you got from others. But here's the deal, just to use my, because I looked this up last night about 1 in the morning. I couldn't sleep. I was on West Coast time, and so I went to the site where this stuff is disclosed for us. That's the Federal Election Commission site. So I could easily find all the documentation for my dear friend. I just happened to go to her contribution history for last year, and only $30,000 of the $296,817 that she got from PACs would be disclosed as a result of this, which is about 10%. But she was able to have another $400,000 or thereabouts from individuals. So you're really down to only seeing a tiny little window of about 5% or less that would be disclosed in the public file of a broadcast, satellite, or cable operator or radio, which, by the way, is all on paper, at least for now, and not online. I was able to ferret out this information online last night, 1 in the morning, or thereabouts. The other thing it does, I think it draws in every candidate in America the way this is listed, because when you read the actual language of the amendment, it talks about political programming and defines it as meaning programming that communicates a message relating to any political matter of national importance. So I'm thinking about a city that's having a fight with the federal government over some new federal regulation. That would be an issue of national importance. Or if in a local community they were fighting about something, again, that I don't know, Second Amendment rights, First Amendment rights, that would be an issue of national importance. And further, the language talks about a legally qualified candidate for public office, so that would seem to be any candidate for public office at any level. So then you have public broadcasting that could be pulled into this because they have people that underwrite programming that deals with issues of national importance. So could that be that every public broadcaster would have to disclose somehow everybody that's paying for that programming? Then you have the creative minds of the people who try to hide from disclosure. This would be real simple under this amendment, because it says the look-back period is back to the last federal general election. Whatever donors you've had at $10,000 would have to be reported before you can inquire about buying time and purchasing time. Well, it's not a reach to think that these clever little rascals out there would simply create a new committee every time they wanted to buy time. That's easy to do. They got lots of money. They got lots of attorneys. They just create the committee to attack Anna Eshoo, 2012. And it has no prior donors from the 2 years. So they escape this. They escape this. And who among us here thinks that they won't do that? So I don't think the amendment's written to accomplish the goal, and that the goal is best achieved and accomplished through the Federal Election Commission, not the Federal Communications Commission. So we're about 2 letters off, and I think it really raises a host of issues that are unintended consequences and should be defeated. And I yield back the balance of my time.
The gentleman yields back. The question is on the amendment offered by the gentlelady from California. Those in favor say aye. Those opposed say no. In the opinion of the chair, the noes have it. The amendment is not agreed to.
Mr. Chairman, I'm asking for a recorded vote on that amendment, please.
Pursuant to Clause 6 of Rule 18, further proceedings on the amendment offered by the gentlelady from California will be postponed. It is now in order to consider Amendment Number 6, printed in House Report 112-422. For what purpose does the gentleman from Oregon seek recognition?
Mr. Chairman, on behalf of Mr. Diaz-Balart, I have an amendment I'm going to offer.
The clerk will designate the amendment.
Amendment Number 6, printed in House Report Number 112-422, offered by Mr. Walden of Oregon.
House Resolution 595. The gentleman from Oregon, Mr. Walden, and a member opposed. Each will control 5 minutes. The chair now recognizes the gentleman from Oregon.
Thank you, Mr. Chairman. Throughout the course of the debate today on the floor, we'll have amendments offered by Republicans and Democrats, a total of potentially 10. This is one offered by my colleague from Florida, Mr. Diaz-Balart, which we will be supportive. There will be at least one amendment on the other side we'll be supportive of as well. This one required the FCC to make additional disclosures on its website and in its annual budget regarding its processing of Freedom of Information Act requests. Now, I think this does fall in the category of reforming how the FCC operates in a positive way. It would increase the agency's transparency with regard to how it complies with Freedom of Information Act requests. Additional disclosure and transparency is a good thing, and the burdens on the FCC are clearly modest completely. And so I would urge passage of this amendment, and I yield back the balance of my time.
The gentleman yields back. For what purpose does the gentlelady from California seek recognition?
Mr. Chairman, I rise in opposition to this amendment.
Gentlelady is recognized for 5 minutes.
Thank you, Mr. Chairman. Obviously, my colleagues know that I'm a strong proponent of openness and transparency rules in government. I'm concerned about this amendment because it seems as if it would apply special Freedom of Information Act, FOIA requirements on one agency alone. And as with the underlying bill, I'm concerned that this would create confusion and inconsistency. I also question what the problem is that we're addressing here, most frankly. Just 2 weeks ago, Chairman Issa, the head of the chairman of the committee with jurisdiction over FOIA matters, issued a report in which he gave an A grade for FOIA compliance relative to the FCC. So it's also my understanding that the FCC is already publishing on its website logs for tracking and responding to and managing FOIA requests. So it's a little confusing given what Chairman Issa and the grade that he issued relative to the FCC and FOIA requests and the issues that I raised, and I think that perhaps the amendment may be redundant or simply not needed at all. So those are my observations, and I yield back the balance of my time.
The gentlelady from California yields back. The question is on the amendment offered by the gentleman from Oregon. Those in favor say aye. Aye. Those opposed say no. In the opinion of the chair, the ayes have it. The amendment is agreed to. It is now in order to consider Amendment Number 7, printed in House Report 112-422. For purposes, the gentleman from New York seek recognition.
I rise in support of my amendment to H.R. 3309.
The gentleman will suspend. Does the gentleman have an amendment at the desk?
Yes.
The clerk will designate the amendment.
Amendment number 7, printed in House Report number 112-422, offered by Mr. Owens of New York.
Pursuant to House Resolution 595, the gentleman from New York, Mr. Owens, and a member opposed, each will control 5 minutes. The chair now recognizes the gentleman from New York.
Thank you, Mr. Speaker. I rise in support of my amendment to H.R. 3309, the Federal Communications Commission Process Reform Act. I agree that cost-benefit analysis is an important factor that independent agencies should consider before issuing new rules and regulations. To that end, I have supported bipartisan legislation that would require other agencies like the CFTC and SBA to conduct similar analysis. Mr. Speaker, in our efforts to change the rulemaking process at the FCC, it is important that we consider unintended consequences. My amendment is very simple and limited in scope. It simply expresses that nothing in this Act shall impede the FCC from implementing rules to ensure broadband access in rural areas. I'd like to clarify that this amendment is not intended to influence the current debate concerning the FCC's reforms to the Universal Service Fund. Last year, I introduced legislation that would direct the Department of Agriculture to craft a comprehensive plan to expand broadband access to rural America. If such a plan were enacted under the bill we are considering today, the FCC would likely be required to conduct additional market surveys and analysis that could delay its implementation. New York's 23rd Congressional District is 14,000 square miles and encompasses a large portion of the state's rural communities. My amendment would simply ensure that development of much-needed broadband in rural areas, like my congressional district in upstate New York, is not held up by increased requirements imposed by the FCC under this bill. Whether it is a small business in Messina, Watertown, Oswego, or Plattsburgh, New York, that wants to market its products to customers in Canada, or hospitals that's able to save a life by assessing patient records, access to broadband is critical to creating jobs and growing the economy in rural New York and in rural regions across the country. In many of these areas, there is simply insufficient demand for private industry to justify the cost of building out their networks. Congress must be prepared to help this infrastructure to ensure our economy remains competitive in the global marketplace. I urge my colleagues to support this amendment and yield back the balance of my time.
Gentleman yields back. For what purposes, gentleman from Oregon seek recognition?
Mr. Chairman, I rise in opposition to the amendment.
Gentleman's recognized.